May I please, Your Lordship?
Yes.
Your Lordship, I beg to mention item number 10 and 11, Lordship. Your Lordship, here the leading counsel is DG Hojai. However, since he is indisposed, let the matter be come up on 11 of August.
Ladyship, in that case, if it goes after 15, I mean,
He's saying 11th. 11th August.
Okay, Lordship.
18 is
18th.
yes, it's one additional.
Since his senior is outstation lawyer, maybe that's why.
Is that okay? Okay, then 11.
11, Lordship.
Third learned counsel, Mr. Tushi Tanjan, for the petitioner, who has submitted that the leading counsel is an outstation lawyer and accordingly praised for listing the matter on 11th August. Government is present. Okay, and government is present. List the matter on 11th August.
Lordship, in the interim.
Oh, interim order, past order shall continue till the next date.
Much obliged.
May I please, Your Lordship?
Yes.
I beg to mention item number 5. Lordship, my learned senior is unable to appear today due to his personal reason. So it is our humble prayer that 1 week time may be granted for us.
So when do you want? After 2 weeks?
1 week time.
1
1
week.
week time.
1 week.
Yes,
Okay, okay.
Lordship.
Learned counsel for the petitioner, Miss such, who has made a prayer for listing the matter after 1 week, as the leading counsel, Mr. Elivil Zhao, is indisposed, has some difficulties today. List after 1 week. Learned counsel, Mr. Alezo Kiri, is present for respondent.
Sole respondent.
For the sole respondent. Stop. It's okay with you. List after 1 week.
Much obliged.
Yes.
Yeah, please, Your Lordship. Your Lordship, I would like to make a mention on behalf of Senior Counsel Im Tiwabang. For item number 7, Your Lordship, I'm for the respondent number 1. We are yet to file the objection in the IA, so kindly grant us 3 weeks' time to file the objection.
IA which one? IA 11?
Yes, IA 11.
Okay. Learned counsel, such and such, makes a mention on behalf of Mr. Im Tiwabang, who's appearing for respondent number?
Respondent number 1.
Respondent number 1. Stop. He has prayed for 1 week's time.
3 weeks' time.
3 weeks' time to file a reply in IA 11 of 2025. Stop. Prayer is allowed. Where is the petitioner? Absent. List after 3 weeks. Stop. Petitioner is not present today. Yes, stop.
Obliged.
This is Lordship.
Yes.
Lordship, I beg to mention item number 6, Lordship. On behalf of Indian Song Additional AG, Lordship. I pray that this matter may be listed on 4th of August, Lordship.
When?
4th of August.
4th of August.
Lordship, since he is indisposed.
Learned government advocate and such makes a mention on behalf of Mr. Im Tiem Song, additional AG, for listing the matter on 4th August as the additional AG is indisposed. Stop. List on 4th August. Yes.
Obliged, Lordship.
May it please Your Lordship, I beg to mention here in item number 9. Your Lordship, since my senior is at this post, if the matter can come up after 3 weeks, Your Lordship.
Your senior? Who's your
And
senior?
Longcomer, Your Lordship.
Learned Counsel, MS such and such, who makes a mention on behalf of the leading counsel, Mr. N. Longkamer, to list the matter
After 3 weeks.
after 3 weeks as Mr. N. Longkamer is indisposed. So, Learned Counsel for the Learned Government Advocate, Mrs. Levy, is present to approve the matter after 3 weeks.
Bless you.
For motion from the supplementary course list. Item number 12.
Because fan don't do
Yes, this, my lord. Lordship, the present accused was arrested in connection with special case number 9 of 2025, corresponding to narcotics PS Kohima case number 5 of 2025, under sections 21C and 60 of the NTPS Act, read with section 61 of the PNS 2023. The allegation is that he has connections to this somebody else, who is the applicant in item number 13. He was caught in possession of 334 grams of suspected heroin. And after the case of the prosecution is that during interrogation by the police stated that the item belongs to the present applicant. And that is how merely on the statement given by the co-accused, who was arrested with the contraband, the present applicant was arrested. Now, he has been under continuous custody and is presently lodged at District Jail Kohima. Now, my lord, there is clear violation of sections 47 and 48, as well as Article 22(1) of the Constitution of India. I may be allowed to place a single decision.
regarding the grounds of arrest.
Yes, my lord.
You will issue notice at this
My lord,
stage.
my lord.
Who's accepting notice? Third Learned Counsel for the petitioner, Mr. Santiago. So, the applicant accused here is praying for release on bail in connection with narcotics PS case number 5 of 2025 under section 21C and section 60 of the NTPS Act, read with section 61 of the BNS 2023. Stop. The Learned Counsel for the petitioner submits that the accused was arrested on 6/5/2025 in connection with the aforementioned case, and he has been in custody since then. Stop. The contention of the petitioner is that the grounds of arrest have not been supplied, have not been supplied.
It has been, but it has not been supplied in terms of the provision of law.
Okay, that the grounds of arrest have not been supplied to the present accused in terms of the provisions of law. Stop. Issue notice returnable within, how much time will it take?
3 weeks, Your Lordship.
Returnable within 3 weeks?
My lord, it will be 2 weeks because it's a Kohima case.
Okay.
Returnable within 2 weeks. Stop. Learned PP, Ms. Levika has accepted this on behalf of the state respondents, and hence no formal notice is called for. Stop. Petitioner shall supply a copy of the petition on the Learned Government Advocate within the course of the day. During the course of the day. So, this after 2 weeks.
Much obliged.
For motion, item number 13.
My lord, if similar order can be passed.
Okay, different accused.
Different accused,
Different
same
accused,
case, same
similar-
FIR.
Same order, but then just change the name of the accused. Okay.
Deeply obliged.
Yes. Then 14.
For motion, item number 14.
Oh, this is yours. Yes.
Notice may be issued, madam. This is valid. If this can be made returnable on first Friday.
No, depends the learned PP when they can produce.
Oh, you are there? Okay.
This is a bail application filed under Section 483 BNSS, praying for release of the accused, Mr. Likao, Likao, Tungoe, who is presently in custody in connection with East PS case number, Dimapur East PS case number 0087/2025. Learned PP Viveka has accepted notice on behalf of the state respondent, and hence no formal notice is called for. On the next occasion, on the next date, the learned PP shall obtain instructions and the case diary. List on.
2 weeks here. That's it.
My lord,
This is
long.
Dimapur.
Yes,
So
but,
it may take. Of course, you can get the scanned copy also.
Yes.
Scanned copy of case diary.
in the interest of justice, at least when the man is in jail.
So, 11th. 11th. Do you need extra copy? 12, okay. Do you need extra copy?
No, Your Lordship, it should be okay. Just telephonically.
Much.
12, yes.
12.
For admission, item number 1.
Please, Your Lordship.
Yes.
Your Lordship, if Your Lordship may kindly see the last order dated 22/7/2025. Page, if I may read the last page, page 4, last paragraph.
Yes.
As such, this court direct the respondent number 1 and 3 to file an affidavit showing the compliance of the court's order and also to reflect the step taken by the government or the authority concerned as per the memorandum dated 17/3/2015 towards regularization of the petitioner service. It is also directed that the concerned authority may consider the regularization of the petitioner service within this month in view of clause 2 of the said OM dated 17/3/2015. The affidavit may be filed by 28/7/2025.
Filed, affidavit filed?
Yes, they filed the affidavit.
Okay.
I just received just now.
So where is that? So has your grievance been addressed as court order is complied?
No, Your Lordship.
Your Lordship, as directed, I filed yesterday the affidavit.
I think it's before the court. When did you file?
I filed
28, that means
yesterday, that is 28.
28. It's not here.
If it is filed, so they are not likely to know. Filed.
Let's see your copy.
Lordship, may I read paragraph 4,
Yes.
the relevant?
Yes. Or let it come up tomorrow along with the affidavit. Or it can be called up to some time. You call for the affidavit and then you call out the. Just wait for some time, okay? You tell the section to send it, okay, Koza? Return this.
For admission, item number 2.
Yes. What
Lordship,
is the matter?
in the previous order 24/6/25, the respondent they sought for 3 weeks time. but as of date, I was not paid.
Release of edition. Oh, cha.
So,
Yes, this matter is being kept for a long time. What happened?
Lordship, I'm representing this respondent number 2, that is the Chief Engineer, PWD RNB, and Executive Engineer, PWD RNB Nagaland. 3 and 4.
Then
Lordship,
I think at one point of time it was submitted that sanction is already given and it was sent to the
Yes, yes.
Noklak division.
80 lakhs was given. 80 lakhs
Then you submitted that
was given.
he's not coming.
And then 90.
no, in that case, Your Honor, Your Lordship, I'm sorry.
okay.
In your last order, that is, in the last order, so Your Lordship has directed that let them pay rupees 80 lakhs to the petitioner. Accordingly, when petitioner was paid this 80 lakhs, I don't know why they have deducted 5 lakhs. That I do not know. Even the petitioner do not know. He was paid 75 lakhs something. So we have given the money receipt also in the last occasion, as I was out of station. So Lordship, now they have to pay the balance amount of 97 lakhs 54,000. Lordship, my client was never called despite the order being given by this honorable court. Different directions were given. Only the excuse they make is that it was placed for the finance for additionality fund. This is not an excuse, Your Lordship. They have to comply with the order given by this court. Only compliance report is required by this court. A strict direction may be given, especially to the respondent number 4. Chief Engineer?
4 and 5.
Respondent number 4. Respondent number 4 is the one who is the Chief Engineer, Lordship. Yes. A strict direction given to comply with the order and pay to the petitioner within a period of 2-3 weeks, Lordship.
What happened? What happened? If they are not willing to pay, let them come to
Yes.
the court and explain
Yes, Lordship.
why they are taking so long. Respondent number 4. Third running counsel for the petitioner, Mr. Sharif, and also Mr. Muaim Chen for the respondent number
3 and 4.
3 and 4, and Mr. V. Jimogni for respondent number 2. What about 5? No one is representing.
5 is the executive engineer. Executive engineer.
I'm representing.
5 also. Sure. Then that means you are for 3, 4, and 5, isn't it?
Yes.
3, 4, and 5, and Mr. V. Jimomi is for respondent number 2. On 24/6/2025, Mr. V. Jimomi had submitted that the approval of the finance department is still awaited for the release of the additional amount of rupees 97.54 lakhs, although the proposal for the pending bills were placed before the government on 8/10/2024. He had therefore prayed for another 3 weeks' time, within which the pending bills would be paid. So, however, when the matter is called out today, the payments are still not paid to the petitioner. So, this COP 37 of 2024 has been pending since. When did you file it? Has been pending since
1811.
18/11/2024. And the order of this court was passed on.
11/12/23.
Where is the order?
There is arising out of the WPC.
No, that's why. WPC order, where is it?
11, annexure.
Page.
Yes. It is page number 23, annexure 1. operative part will be para 7, Lordship.
Order dated 11/12/2023, passed by this court in WPC 19 of 2023. Stop. Accordingly, on the next date, the respondent number four, respondent number 4 shall appear, is directed to appear before this court to explain as to why the directions of this court has not been complied with till date. Stop.
2 weeks.
List on. No, we have to give a date.
Okay. Yes, Lordship.
He can appear on 11th. Let him appear on 11th August.
Yes, Lordship.
Fixed on 11th August for appearance of the respondent number 4. A copy of this order to the learned counsel appearing for respondent number 4.
Deeply, Lordship.
For admission, item number 1.
Yes, the affidavit has come, Mr. Moa, so
Yes, para 4.
take us to the relevant.
Relevant is para 4 and 5. May I read your Lordship?
Yes.
Para 4. That the answering deponent most respectfully states that the Department of the answering deponent has taken exigent initiatives for regularization of the petitioner by following the courtal procedures which is stipulated in the Office Memorandum dated 17/3/2015. It is stated that in order to regularize an employee serving as work charge and casual employee must, at a threshold, be verified by the district level verification committee in host district the employee was serving. It is very categorically enshrined in Para 1, Roman 1A, the OM itself. However, there was an inherent lapse during the process as the name and particulars of the petitioner could not be verified by the district level verification committee, and hence the petitioner's case could not be processed for further action to the concerned authority. Number 5. It is most respectfully submitted that the Department of Personnel and Administrative Reforms Department, PNR, has issued a circular dated 22/7/2025, wherein all the departments in the state are directed to submit the list of all employees to the committee for re-verification of the contingency, facts and wage paid employees, and those work charge and casual employees who have missed out the verification conducted by the district level verification committee in 2004 to 2016. That means your leadership district level verification committee was set only during 2014 to 16. From 16 it was not set and appointed on or before 6/6/2016. The Department of the answering deponent will be initiating this to submit the name of the petitioner on the basis of this benevolent circular. It is, however, respectfully stated that the Department of the answering deponent will definitely take some more time, as the process is lengthy, and as such, the answering deponent brief for more time. Your leadership is well aware. After the district level verification is done, wherein Deputy Commissioner is the chairman, it has to come to the department, and from there, it has to go to the departmental secretariat, and from there, it has to go to the BNI. It has to update that finance, and then to the manpower rationalization committee, and then last to the cabinet. That is the procedure. So, in the process,
No, but the court's order is 2022 court order.
But Lordship,
Now it's 3 years.
yes, that is the thing. That is what I have explained in the Bharat 4. The petitioner's name was not verified by the district level verification committee. That means from the concerned district, his name could not be verified. So because of that lapse, he has to be included in the present exercise only. That is a problem. That is why the time consumption was caused.
So now, in paragraph 5, you have stated that the state respondents will take some more time. So how much time?
Your Lordship,
Your Lordship,
Yes.
it was his submission on the last occasion. So the court has directed the state to show the compliance of the court's order and also to reflect the step taken by the government as well as the authority and to regularize the service of the petitioner in terms of OM 17/3/2025 in as per clause 2 of the state OM.
So what is the stage
That,
now?
that was the submission on the last occasion as well. So the court has directed
And in fact, in the last para, it says concerned authorities may consider the regularization within this month. Within this month, it says. So what is the stage? What is the stage now?
Your Ladyship, as you are well aware, the process.
No, process is there, no doubt.
Process is there.
But why
But-
give an
but-
undertaking if you cannot comply within that time? You have already submitted to the court, before the court.
No, that is the latest development. Lordship, kindly see page 13. Page 13, the circular dated 22nd July 2015. So on the basis of this circular, we are going to initiate the verification of the petitioner. Only after verification by the district level committee, the entire process for regularization will be started. The district who was serving,
Of course, learned counsel in the court order, in BC 250, no specific time frame is given. in the
yes,
direction.
Your Lordship. But they state themselves they supported my case
Yes.
and
No,
the direction was
they
to-
will do
yes.
it, they will do it, but then the problem is they are taking too much time, that is the only thing. And during the district level verification, your name was not put up.
he was missed out.
You
By-
were missed out
Some
By-
inadvertent error, he was missed out. Because
by
district
the
level,
staff in the district.
district level verification committee, it said only 2014, 15 and 16. After that, no district level verification was set. So only this time we are going to set. So we are going
But
to,
it should sit every year, isn't it?
it should be,
Actually, it
but
should sit every year.
it is not every year exactly, but sometimes it is also miss out.
Your Lordship, in my contempt petition, page
And,
14,
and so far as this,
page 15, clause
in the
2.
writ, in the order and direction in the writ petition, no time frame has been given.
Page 15, yes.
Yes, in clause 2, Your Lordship, it says that in respect of those work charged in casual employees in scale pay and who have completed or will complete 30 years of continuous service after 1/1/2015, their case for regularization will be taken up subsequently in 2 batches as on
Yes.
1st July and 1st January
July
every
and
year.
1st January every year.
Yes,
Mr. Moa, it's reflected in the OM itself.
It is reflected in
every
the.
year,
Yes,
twice
yes,
a year.
Yes, yes. It is reflected in the
Yes.
OM itself. But your Ladyship, please come to page 14, the beginning.
It appears that
Regularization
you are
of
not,
service.
it appears that you're not following your
Regularization
own
of service.
OM. Yes.
Roman 1A. The incumbent concerned.
Page 14.
A.
page 14 and next year.
Page
yes,
14.
yes,
Annexure A. The OM itself.
Ah,
The incumbent concerned in his or service rendered as work charge casual employee has been duly verified and found genuine by the district verification committee constituted by the government. Availability of service records, including appointment order, date of initial appointment, proof of length of service, age, etc. So this is the first question. Only after this verification is done, only after that the question of submitting 2 phases in January and July will come. This is the first elementary duty that the petitioner has to complain.
Okay. The
Without this, we
okay,
cannot
an
decide.
additional affidavit on behalf of respondents 1 and 3, as per the direction of this court, by order dated 22/7/2025, has been filed by the respondents. Stop. Learned counsel for the petitioner is present, as well as learned counsel, Mr. Moa Imchen, for the respondents number 1 and 3. So, Mr. Moa Imchen submits that the case of the petitioner was not included during the verification by the district level verification committee due to inadvertence.
Due to some
Due to-
inadvertent
yeah,
lapses.
Due to some inadvertent. Stop. And therefore, the concerned department has initiated the process to submit the name of the petitioner for consideration under the OM dated 17 March 2015. Stop. It is also submitted in the affidavit that the deponent will take some more time, as the process is lengthy, and as such, the deponent has prayed for how much time? 3 months.
Lordship,
3 months, 3 months. You
3 months.
finish it in 3 months. It is a court direction within 3 months. Stop. This court has considered the prayer of the respondent number 1 and 3. It is also observed that this court, while passing the order dated 10/11/2022 in WPC 250 of 2022, had not given any specific time frame to the state respondents to regularize the service of the petitioner in terms of the OM dated 17/3/2015. Stop. However, it is expected that the respondents 1, who is respondent 2? Oh, okay. However, it's expected that the respondents 1, 2, and 3 shall comply with the direction of this court within the period of 3 months as prayed for. Stop. We will list it after a month, and in the meantime, you update the court about the status, okay? You have to keep updating, otherwise, list the matter, the 1 month, on which date the respondents 1, 2, and 3 shall submit before this court.
Much obliged.
Lordship.
For admission, item number 3.
Lordship,
Yes,
I may be allowed to appear through VC since I am in Orissa High Court today, Lordship. And in view of the gravity and seriousness of the case, I was supposed to come and appear personally today, but since I was caught up late in the court yesterday, I could not reach the court on time today, Lordship. This is a criminal revision filed under section 442 of the PNSS 2 2023, or in the alternate section 397 of the CRPC, Lordship, for setting aside and questioning of the impugned orders dated 35/2025 of the Honorable Judicial Magistrate Voka, and consequently for discharge of bail bonds of revisionists and release from prosecution of the petitioner's lordship, may kindly refer to the last order given by my honorable lordship dated 26/2025,
20,
lordship. 6/2025 passed by my lordship. Yes. May I read, lordship?
yes.
26/2025, lordship. May I read, lordship?
Yes, please read. Please read.
Order 26/2025 heard learned counsel for the petitioner revisionist Mr. S. Srivastava along with learned counsel Mr. N.Z. Lotha. Now, in the next paragraph, it is written, this is an application under section 442 of the BNSS 2023, or in the alternate section, this is a mistake, section 397 of the CRPC, for setting aside and question of the impugned order dated 35/2025, passed by the learned judicial magistrate first class Vokai in GR case number 74/2019, under section 128, 129, 223 of the IPC. By the impugned order dated 35/2025, the learned judicial magistrate first class Voka has dismissed the IA filed by the petitioner herein, praying for discharge in the case. The petition has been filed on the following grounds, Lordship. Number one, no cognizance in the offense has been taken by the magistrate before issuing the summons to the present petitioners. Number two, that no prosecution sanction was given before the proceedings were initiated against the present petitioners. Number three, that the duty of warder is not the custody of the UTP or convict, and therefore they are not responsible for custody of the escaped UTP, Lordship. In this order, Honorable Lordship has asked from the trial court its records, and then the records are have been sent by the trial court before this Honorable Court, Lordship.
Yes.
So my Lordship may kindly peruse the this case diary of the Learned trial court, Lordship.
Yes.
Your Lordship, letter LCR has been,
LCR has come.
Your Lordship, now the question is like now they're praying for discharge of their petition, Your Lordship,
Yes.
on three grounds. That is the trial court has not taken a cognizance, Your Lordship. Now we have to see the
Prosecution sanction.
Yes, we have to see whether the
Duty of the warder. Okay, that is on merit.
yeah, whether cognizance has been taken or not. And as far as the prosecution of sanction is concerned, that we will come later. But we have to firstly see, Your Lordship, whether cognizance has been taken or not, Your Lordship, because LCR.
You have gone through. Have you gone through the records?
I have no control. My apology, Your Lordship, on the last date, Your Lordship. I think the matter was fixed and I overlooked the matter and AGM appeared on my behalf. So the matter is fixed today, Your Lordship. So unable to actually go through the
Actually, you
LCR.
should go through and then assist the court. No?
Yes, Your Lordship. So, Your Lordship, if sometime may be granted so I can go through them, Your Lordship.
Lordship.
Yes.
Lordship may kindly peruse the gas records that is placed before.
No, it is here.
you.
But learned PP
Yes.
is saying that she had no opportunity to go through the records. That's why we're just discussing that.
Yes, Lordship. This is the second occasion.
No
This is the
problem.
Tomorrow? We'll take it up tomorrow.
Tomorrow, Lordship.
Yes, because
Lordship.
the PP has to assist the court. No?
Yes.
Lordship.
Tomorrow is division bench. Your
Oh,
Lordship.
yes. Thursday.
Lordship.
Yes.
In that case, the trial court matter is fixed for tomorrow. So, according to this order, the interim will be considered in the last. That is what my honorable lordship has given in the last occasion. So,
Okay, we will extend it.
Yes, Your Lordship, that can be done. Till Thursday.
What was your
In the
interim
last-
prayer? Your interim prayer was to stay the proceedings.
Lordship, yes, Lordship. That is my humble prayer, Lordship. Maybe this honorable court, my Lordship may
Otherwise,
stay the
7, 8.
Otherwise, we will request this honorable court to list the matter tomorrow also. We have no problem, Lordship.
Tomorrow is division bench day, that's the problem.
Your Lordship,
The trial,
we just go for some time and meantime other matter can be taken
Okay,
up.
okay, let's do that. Yes.
Lordship.
We'll call after something.
Lordship.
For admission, item number 4.
Am I audible? Am I audible?
Yes, yes.
May I please, Lordship?
Yes.
My Lord, by order dated 24/7/2025, I was directed to obtain instruction whether the statement of the accused has been recorded or not. And my Lord, I'm informed that he has not appeared. But in the last night, the investigation officer, he called me up and he said that accused appeared at around 8 p.m. So, since he appeared late, that is why his statement could not be recorded. So his statement will be recorded today.
Today.
Yes, I was informed by the investigation officer.
May it please your ladyship, this is the second time I'm appearing, and the last time he had gone to the police to comply with the honorable court's order. His
No,
statement
but
was
it is the accused who didn't appear, nah?
Yes,
The
ma'am.
accused appeared only last night, that was so late at night. So they could not record the statement.
he had appeared earlier on the 9th of July as well, and somehow his statement could not be
Only today
recorded
they are recording the
that time
statement.
as well.
Yes, yes. So Thursday, learned counsel, learned PP, Mr. Tipapong, submits that the accused appeared before the investigating officer only at 8 p.m.
If I may speak,
Yes.
if I may please your ladyship, he's not a main accused person on the FIR. And in the same matter, the co-conspirator, as mentioned by the accused person, has been granted an absolute anticipatory bail on the 7th of this month by this honorable court and the vacation bench. And in fact, the main accused is out on bail as well. So, the common string that ties all of us is to be able to meet justice
No,
for
but
the client as well.
at least the
And
statement of the accused has to be produced by the
Yes, my
court.
lord. Yes.
Without that, how can we pass any order? We cannot. The learned PP
he lives within the jurisdiction of this honorable court, my ladyship, and he
after
travels
only
from
one day.
Assam to Nagaland.
Only one day. The court has to see the statement. Learned PP submits that the accused in the present petition appeared before the investigating officer only on only at 8 p.m. on 28th of July 2025. Stop. And thereafter, his statement is being recorded today, that is 29th July, and accordingly the statement of the recorded statement of the accused could not be produced before this court when the matter is called. Let's stop. Learned PP has accordingly prayed for listing the matter on Thursday, okay?
Thursday, okay.
On Thursday for further orders. Stop. Learned counsel for the petitioner, MS such and such. Kalita, Miss Kalita.
That is right. Your
Yes, Kalita is present through VC. So, this is the matter on
31st.
31st July.
Much obliged.
Much obliged.
For orders, item number 8.
May it please your ladyship.
What is this?
My lady, while preparing this revision petition, the present revision petition, there was a 10 days delay in filing the same. Therefore, an IA has also been filed. And in the last occasion, I was permitted to serve notice through Dusty as well as registered post.
Done.
My lady, while serving the Dusty, despite clear instructions, the service of notice was served to the daughter-in-law of the respondent, who assured that the same will be pass on to the respondent. Perhaps because of that reason, the respondent is not here yet before this honorable court. Therefore, I may be kindly be permitted to serve Dusty once more to the respondent himself.
Yeah, on the respondent himself, that is better. Learned counsel for the petitioner, Mr. TKG, submits that this court, by order dated 14/7/2025, had allowed the applicant to take steps for notice on the respondents. One respondent or
Only one
sole
respondent.
respondent, no?
Sole respondent.
Take notice on the sole respondent by registered post as well as by dusty mode. Stop. It is submitted that the notice upon the sole respondent was served on the sister-in-law,
To the daughter-in-law,
served to the daughter-in-law,
who lives adjacent to the residence of the
who
respondent.
lives next to the residence of the sole respondent. Stop. However, today when the matter is called, none appears for the sole respondent. Stop. Accordingly, the petitioner is allowed to take steps by dusty mode on the sole respondent himself. Stop. And list the matter when? After a week?
After
1 week. You filed the affidavit also?
I filed my affidavit, my lady. However,
Regarding the
at
service.
para 3, the fact that it was served to the daughter-in-law due to inadvertence, it has not been incorporated in the para 3.
You have only stated respondent 1.
Lordship.
Then
That
you
was
file
due to
another.
inadvertence.
Then you file another affidavit, and thereafter the applicant / petitioner shall file an affidavit declaring about the service of notice on respondent number 1 or on the sole respondent. At
Lordship.
least after 1 week.
Highly obliged, Lordship.
For admission, item number 3.
It's there.
Yes, Your Lordship, there is.
Otherwise, there is a loose sheet here also. I think it came out from the reports. Order dated 7/8/2024.
Yes, there is 1/7.
Exactly, Lordship.
No, cognizance is taken by this order,
Yes,
7/8/24.
Lordship, I appeal to the wisdom of this honorable court. If my lordship will peruse the lordship given by the judicial magistrate, may I kindly be allowed to read, Lordship? It is written, I have perused the charge sheet and materials available on case record and finding sufficient incriminating materials. Cognizance for offense punishable under section 224 IPC is material, Lordship, against the accused person. Issue summons the accused person fixing 5/9/2024 for APP copies, Lordship. Now, this cognizance has been taken without following the due process of law. Number 1, prosecution sanction under section 197 was not taken, and without prosecution sanction being taken against the accused persons who are government employees, the magistrate could not have proceeded, learned magistrate could not have proceeded against the accused people who are before this honorable court, Lordship. Secondly, as my lordship will see, now cognizance is taken only under section 224 IPC. Now the present applicants are charged with section 129 IPC and section 223 IPC only as we can find in the chart sheet, which is given in Annexure R3, batch 51, Lordship. Batch 51, Lordship. Batch 51, and the relevant part is batch 54 in the chart sheet, Lordship. Batch 54. Batch 54 of my revision petition, Lordship. Lordship, may kindly come to the third paragraph. May I read, Lordship? May I be allowed to read, Lordship? Investigation could not be established under Section 128 IPC, as the escape was done without any help or assistance from the jail warders and 7 NEP personnel who were on duty. I therefore request the Honorable Court to kindly omit Section 128 from the instant case. Now, investigation has also established beyond reasonable doubt that the escaped UTP inmate accused has committed the offense under Section 224. Now, cognizance has been taken only under Section 224 against the UTP. Now, may I continue to read, Lordship? Whereby, escaping from custody in which he was lawfully detained, it is therefore brought to this Honorable Court to kindly add Section 224 IPC in the instant case. Investigation has also established Section 129 and 223 as the duty personnel of 7 NAP and district jail has negligently suffered a prisoner to escape from the place of confinement, Lordship, in the next paragraph. Hence, a prima facie under Section 224 is found well established beyond reasonable doubt against accused number A1, Zadeo Odeo under so and so under section so and so. And under Section 129 and 223 against the accused A2, A3, A4, A5, A6, A7, A8, 9, 10, like that, Lordship. So, this learned magistrate has only taken cognizance against the UTP accused number 1 and has taken cognizance only under Section 224 IPC and not against the accused person before this Honorable Court, praying for revision of the order of the single judge Lordship of the learned trial court Lordship. Therefore, now, as per the law of the land, Lordship, as per the law of the land, there cannot be supplementary cognizance also. There cannot be supplementary cognizance that can be taken by the learned trial court again. In view of this, the entire proceeding is required to be quashed now, Lordship, because if no charge is framed against me, if no cognizance is taken against me,
persons are government employees. They are all government employees, isn't it?
yes, sir. Yes, Lordship, all the accused people are government employees. Especially before this Honorable Court, only 4 applicants have come for revision, Lordship, which are A4, A5, A6, and A7, Lordship.
A4,
A5,
5,
A6,
A7.
yes, sir. A4, A5, A6, A7 are temporary employees, Lordship. They were.
Then in the charge sheet, against A4, 5, 6, and 7,
Lordship.
the sections of law are 129 and 223 IPC.
Lordship, exactly, Lordship.
Yes, Livika, it's like this. The court below had taken cognizance under Section 224, okay? But then only A1 is charged with 224.
Yes.
And the rest of them are charged under 129 and 223.
Yes.
Whereas no cognizance is taken under 129 and 223.
Yes, Your Lordship. Yes, as far as the record
Yes,
goes, it's
yes.
showing like that, Your Lordship.
Yes.
Now,
So some problem
yeah,
is there.
some problem is there, Your Lordship.
no,
Lapses
just
is there, Your Lordship. But
lapse is
now, Your Lordship, what
And
measure
then
should...
prosecution sanction also?
No, Your Lordship, here, as far as the prosecution sanction is concerned, Your Lordship, the accused, they were arrested on 23/12/19, and these 4 persons who are presently before this court as a revisionist, they were terminated on 28/12/19. As per the charge sheet, Your Lordship, they were terminated from the service on 28/12/2019, and therefore it was not felt necessary to obtain prosecution sanction in
Terminated
respect to this 4 persons.
Terminated on
28/12/19, they were terminated from
12,
service.
2019.
Yes.
And when was the charge sheet filed?
Charge sheet was submitted in the year 2024, Your Lordship.
2024. That means much
2
after
for
they were
2000.
terminated.
Very, very much, Your Lordship. It is just like a matter
6
of
for
6-5
24.
days after they were arrested. After 6-5 days, these 4 persons were terminated from service. Whereas the rest of the person against whom a prosecution sanction was obtained, they were not terminated, and therefore the prosecution sanction were obtained against those persons. But against these 4 persons, these 4 revisionists are before this court. These are the persons who have been terminated from service, and therefore prosecution sanction was not deemed necessary, Your Lordship. So that is the reason, Your Lordship. Now, as far as the cognizance is concerned, Your Lordship, yes, it is apparent from the record that is, the cognizance has been taken against 2 to 4. Now, Your Lordship, the revisionists are coming before this court for discharge from the case. Now, it's an admitted fact that a UTI, Your Lordship, UTP, the trial prisoner has been escaped, Your Lordship, when they were being detailed for duty, Your Lordship. They have said that they have been on leave, but it was an arrangement, it was an internal arrangement as per the record. There was never, it was not taken officially. Whereas it was officially, they were officially detailed on duty, and it is an admitted fact that UTP has escaped while they were being given detailment duty. Now, that is an admitted fact. So, can we, just because there were some lapses in the trial court, can we just discharge them without taking proper evidence, or maybe proper section has not been completed? Can we just discharge them like that? I think that will not be fair. So my humble prayer is that, Your Lordship, if it's not being correctly done, let it be directed, appropriate orders may be passed so that the trial court take appropriate step in taking the cognizance, the right section can be included, and accordingly it can be tried. And when it is tried according to law, maybe if it is not found, maybe they can be discharged. But at this stage, seeking for discharge from their liability, Your Lordship, will not be fair. So that is my humble submission, Your Lordship.
Lordship, as the law of the land is there cannot be supplementary charge, there cannot be supplementary cognizance that can be taken by the learned trial court also. And without cognizance under section 190 of the CRPC, trial court cannot proceed against the trial of the accused people. And secondly, Lordship.
Yes.
Secondly, Lordship, my honorable sister is arguing that the warders, the present accused have been given in charge, given the custody to take care of the inmate, while the inmate, this UTP, was in jail. Now, I would like to bring on record and to take my lordship to page number 211 of the petition.
I'm interrupting my counsel, but Your Lordship, it cannot become under trial, Your Lordship. As of now, it is better to go into all these things. Now we just have to see whether cognizance has been taken or not. It has been wrongly taken, so maybe we can direct, yes.
And then against, where is the impugn order? And they are against that refusal of the discharge also?
Yes, Your Lordship.
Where is that impugn order?
Impugn order is
the discharge, the proposal of the discharge order.
And even in that order, the
46, Lordship.
46.
46, Lordship.
Basically, they are coming against that.
Yes.
This order.
So this order, of course, Your Lordship,
Matter was heard
it, this order they have said that it is too premature to go into it. However, Your Lordship, we have seen the lapses, so Your Lordship, not for discharge, but appropriate orders can be passed, Your Lordship.
Acha, and another thing, when the discharge petition was taken up before the learned court below, you have not raised these grounds. These grounds which are taken up now have not been taken.
Yes, that's true.
Regarding the prosecution sanction and then regarding the non-inclusion of section
That's true, that's true.
223 and 223 and what was that?
224. 224.
No. Another section was charged
129.
against the other.
123, 129, and 224.
129 and 223. Those grounds were also not taken before the learned court below.
Lordship, for question of petition, such infirmities cannot be brought against the trial court also. Therefore, we have to approach the Honorable High Court for revision, a true revision on this, Lordship. And if there is...
While filing for discharge, all these grounds can be taken. Why not?
Lordship, as my Lordship has clearly seen in the petition that on the case records that if cognizance is not taken, because those are found later on also, Lordship. After perusing all the records, we have found later. Initially, this cognizance was not there in the file records, Lordship. And if I have to go deeper, then there will be serious. There will have to be. There could be some serious lapses. There we can find serious lapses also. So I do not want to go into the details of these issues also, Lordship. And when there is before this revisional court, Lordship, if there are all these infirmities in the cognizance and in the cognizance order and on the issues that are being raised before this honorable court, then even
BNSS. You have filed under 442 BNSS.
Lordship, for revision, Lordship.
Are you relying on any authorities?
Lordship, at this stage, I cannot bring any authorities because as the court records clearly shows, there is no need to proceed with the trial anymore, Lordship, because if there is no cognizance under section 190 of the CRPC, it cannot proceed beyond section 190 of the CRPC, Lordship. And even as otherwise, Lordship, may I kindly take this honorable court to page number 212 of the review petition I have filed, as against the ground raised by the 212, Lordship. 211 is the heading, Lordship.
Prison Department.
Prison Department Manual. In this manual, the prison department has shown who are the duties of each employee. The duties of each employee that are under their, the duties of each employee. And in page number 214, Lord, page number 215, page number 215 of this petition. Lordship, I will like to show whether the present petitioners are in charge of the UTP or not. That is the third ground we have raised, Lordship. That is the third ground I have raised before this honorable court for consideration of my petition, Lordship. Now I will read page number, this manual to page number 215, this para number 12, point number 12. 12. It shows jailer. What is the duty of a jailer? Jailer is the chief executive officer of the jail. He is responsible for safe custody of the inmates. He is responsible for safe custody. Custody is material, Lordship, of the inmates and ensures that proper disciplines are maintained. So jailer is in charge, entirely in charge of the, in charge and in custody of the UTP, number one. Now, point number two is para number 14, Lordship. Para 14, it is given chief head warder. Now the duty of chief head warder is responsible for enforcement of strict discipline and security of the jail in all respect. All locks and keys of the prison cells and kitchen are kept under his custody. He also looks after duty detailment of head warders, female warders, sweepers, and water carrier, and maintains the records of such duties. Chief head warder is assisted by head warder. Now, coming to para number 16, Lordship. Now, these present revisionists are appointed were appointed as warders. Lordship.
They are all
Now,
warders.
what is the duty of warder?
Rivika,
Yes,
they
Lordship.
are all warders.
The present revisionists
They are jail warders, yeah.
Then in
are
that
warders. Now, let us see the duty of warders. Lordship.
yes, I've seen earlier also in charge of work for cleanliness
Yes.
and all that. So the custody, they are not responsible for the custody actually.
No, whatever,
Lordship.
whatever be the cause, my lordship, the technical thing is that your lordship, cognizance has not been taken. Okay, proper cognizance has not been taken. So let proper cognizance be taken. Your lordship,
How
that's
can
lapse.
that be
And
allowed?
your lordship,
If the
Cannot be.
Honorable, my dear sister, if this matter comes before the Supreme Court, the judicial magistrate will be heavily penalized. That is what I feel. Therefore, I don't want to proceed with the matter anymore.
Cannot give
Lordship,
for another fresh cognizance. That cannot be done.
Lordship, that cannot be taken also. And if this matter will go to the Supreme Court, the learned trial court will face difficulty also. Because of that, I don't want to proceed, Lordship. And Lordship, with regard to the custody that I have raised, whether these warders are in charge of the custody, and then whether these warders can be punished under section 129 and section 224, 223 also, Lordship. If my lordship will peruse section 129 of the IPC, Lordship, then section 1.
Yes, I'm disposing. Yes, this is an
Lordship.
application under section 442 of the BNSS 2023 for setting aside and quashing of the impugned order dated 30/5/2025 passed by the learned Judicial Magistrate First Class Woka in GR number 74 of 2019 in connection with FIR number 44/2019 under section 128, 129, 223 and 224 of IPC. Stop. I have heard learned counsel for the petitioner, Mr. N.Z. Lotha and Ms. Livika Learned BP for the state respondents. Stop. This court has also produced the scanned copy of the trial court records, which has been received from the court of the Judicial Magistrate First Class Boka. Stop. Para. The case of the petitioners is that they were serving as,
What is?
where is your synopsis?
It is an election, yes.
The facts of the case, the particulars of the petitioner, para.
It is in para number 2, Lordship, starting from para number 2, Lordship.
No, not this.
In the synopsis, Lordship.
Your particulars and how the case started and all that, nothing is there.
It is not much given in the synopsis. It is there in the main. It is there in the main petition, Lordship. I kindly also reserve the matter and pass accordingly, also, Lordship.
There is nothing here. That the petitioners were serving as warders.
Your Lordship, in the charge sheet that is at para 3, it is written.
Yeah, that is better, I think. Charge sheet, na?
Para 3. It was ascertained that 7 jail warders.
Charge sheet is page.
Annexure 3, page 51. It will be in para 3.
Yes, that the petitioners were serving as jail warders in the district jail Woka, and on 23/12/2019, a complaint report was received from the Deputy Superintendent of Jail Woka to the effect that one UTP, namely Satyo Audio, TSATHEO Audio, had escaped from the district jail Woka at around 5:20 hours. Stop. On receipt of the complaint report and upon checking the CCTV footage, it came to light that the UTP had escaped from the district jail Woka by climbing the main gate, taking support of the hinge, HING hinge attached to the gate. Stop. In this connection, the case was registered being Woka PS case number 0044/2019 under section 128/129/223 IPC, and the charge sheet was filed accordingly. Stop.
Lordship.
Thereafter, the petitioners had filed a discharge application before the learned trial court. From the learned trial court under section 262 of BNSS 2023, praying for discharge of the petitioners from the charges against them. Stop. The said discharge application was disposed of, was dismissed, was rejected by the learned trial court by order dated 30/5/2025 on the ground that the question of whether the accused persons were negligent in causing the escape of the UTP from the jail is a matter to be determined after leading evidence during trial. Stop. The learned trial court held that it would be too premature to come to a conclusion that the accused persons were not involved in the case. Being aggrieved, the petitioner is before this court praying for setting aside and quashing of the impugned order dated 30/5/2025. Para. Learned counsel for the petitioner submits that the charge sheet was filed against the present petitioners and they were charged under section 129 read with 223 IPC. Stop. However, on 7/8/2024, when the learned trial court took cognizance of the matter, the cognizance was taken only under section 224, in spite of the fact that the petitioners herein are charged with sections 129 and 223 IPC. Stop. Learned counsel for the petitioner has also drawn the attention of this court to the RTI disclosure of the prison department, wherein the powers and duties of its officers and employees are set out.
In Manual 2, Lordship. Set out in Manual 2.
Prisoners manual.
In manual, no, this is manual 2 or 1?
Lordship, Manual 2 of page 214. Page 214. The powers and
Roman 2, in manual 2. Stop.
the powers and duties.
At serial number 12, it is shown that the jailer is the chief executive officer of the jail, and he is responsible for safe custody of the inmates and ensures that proper discipline is maintained. Stop. The functions of warder is given at serial number 16, wherein it is stated that the warder is in charge of a ward or set of wards to see that the prisoners maintain cleanliness and also to examine the wards, cells of the prisoners and to report immediately to the jailer of any sign of sickness or any prisoners complaining of sickness. Stop. It is therefore submitted by the learned counsel that
Moreover, prosecution sanction was also not taken, Lordship.
no, that is not relevant because you were no more government employees at that time.
Attendee cannot be dismissed without disciplinary action, Lordship. So that is also an illegality committed by
No,
the
but that termination is not challenged before this in this petition. So that
Lordship.
the termination is a different matter.
I bow down, Lordship.
So I'm not
Lordship.
taking that law. Okay, which para you have stated about the duties and functions? Okay. Therefore, the Learned Counsel for the petitioner states that being jail warders, the present petitioners at the material time were not in charge of the custody of the inmates, and therefore any escape of such inmates from the confinement of the jail would be the responsibility of the jailer or the assistant jailer and not the petitioners. Stop. In view of the aforementioned grounds, comma, Learned Counsel submits that the petitioners ought to have been discharged from the liabilities of the present case and have therefore prayed for quashing and setting aside of the impugned order dated 30/5/2025 passed by the learned JMFC Boka and praise for discharge and praise for their discharge. Stop. Para. Learned PP Livika has submitted that the petitioners had been the petitioners at that relevant point of time had been, you were saying, had been given duty or something like that.
Yeah, as per the record, Your Lordship, it is, and they were given a detailed
Had been
work,
detailed,
yeah, detailed for
the
work.
present petitioners
As
had
per
been
the charge
detailed,
written.
had been detailed for duty on the day when the under trial prisoner escaped from the jail. She has also submitted that 51.
They were said to be on leave, but it is not an official
So
leave.
submitted that the petitioners had stated that they were on leave on that day, but such leave had not been granted to them
Officially.
Officially, stop. Learned PP also submits that though there may be some irregularities in the cognizance order dated 7/8/2024, this court can direct
pass appropriate orders. That can be.
pass appropriate orders to the, directing the learned trial court to rectify the same. Stop. Learned PP also, what is other ground?
Yeah, as far as the prosecution, that,
Yeah, that I'm
so
not,
I think as far as the conclusions, I
Yes,
think.
yes. And moreover, learned PP also states that the question as to whether the petitioners were responsible for the escape of the UTP or not can only be determined after the trial is completed and by considering the evidence taken during the trial, adduced during the trial.
And it's an admitted fact that UTP, like, yes, I think
As it is an admitted fact that the UTP had escaped from the jail. Stop. She has therefore prayed that the present petition may be dismissed. Stop. Para. This court has considered the submissions of the learned counsel for the petitioner as well as the learned PP and has also perused the trial court record, scanned copy of the trial court records. This court, on going through the charge sheet which was submitted on 2/4/2024, has observed that in the charge sheet, the petitioners have been charged under section 129 and 223 IPC. And they have been placed as A1, no, wait.
No, A4,
A4, A5, A6, and A7 in the charge sheet.
Lordship,
Stop.
Lordship.
Where this court has also perused the order dated 7/8/2024, by which cognizance has been taken against the accused persons / petitioners. Stop. In the order dated 7/8/2024, the learned trial court has taken cognizance only for offense under section 224 IPC, whereas as per the charge sheet, only the
UTP accused number 1.
only the UTP / A1 has been charged under section 224 IPC. Stop. Therefore, this court is of the view that the learned trial court has committed an error by not taking cognizance against the present petitioners under section 129 and 223 IPC. Stop. This court has also perused the functions, duties and functions allotted to the present petitioners who were serving as warders in the jail, in the district jail Bukha. As per the disclosure under the RTI Act at Manual 2, Manual -2, Roman 2, Who are you? Law students? Okay, okay. Kohima Law College. As per the manual dash Roman 2, the warders are only in charge of the wards to maintain cleanliness and to report to the jailer regarding any complaints of sickness of the prisoners. Stop. In fact, it is only the jailer and the assistant jailer who are responsible for the safe custody of the inmates. Stop.
Lordship, it is including the chief head warder who are in charge of safe custody. Chief head warder in Bara 14.
Chief head warder.
Lordship.
No.
Jailer
Chief
assistant.
warder is discipline. Discipline only.
And in charge of all the geese, in charge of all the geese of the
All
prison
of
cell.
this. Oh, yes. Okay.
Yeah, under his custody.
Jailer and assistant jailer and in charge of the custody of the inmates. Stop. And it is the chief head warder who is responsible for enforcement of discipline and security of the inmates, and also responsible for and also in charge of all the locks and keys of the prisoners' cells. Stop. Therefore, it cannot be said that the present petitioners were in charge of the custody of the UTP at the time of his escape. Stop. If at all you had given them the duty, it was wrongly done actually, because they are warders.
Lordship,
You
that,
cannot give them the duty of looking after the custody of the
moreover,
UTPs.
like if you, of this record of this manual, Your Lordship, if had there been on duty that day, Your Lordship, maybe their work assigned to them is for cleaning or to see that whether about the well-being of the prisoners. Lordship, if they have been on duty on that day, Your Lordship,
Let it come under service law, Lordship.
skipping of the UTP would not
Let
have.
it come under service law. It is
Off the
within
record of the manual, off the record of the manual.
Yeah, that is okay, but as far as criminal law is
Yes,
concerned,
that, Your Lordship, as per the law, Your
It's
Lordship.
a domain of service law, Lordship.
that can be a different thing. Yeah.
Lordship.
In view of the discussion and observations made here and above, the present petition is allowed. The impugned order dated
35/2025.
35.
Wait, I just want to see the prayer. Your prayer is at page? Prayer petition. Page 44. The impugned order dated 30/5/2025, passed by the learned JMFC Walker, is quashed and set aside. Stop. And the petitioners are discharged from the liabilities of the case in GR case number
GR 74 2019.
GR 74 of 2019.
GR number 74/2019.
FIR number 44 of
FIR number 44 of 2019, pending before the learned
Judicial Magistrate.
Magistrate
JMFC. Buka.
petition says disposed. And this may be returned, and the trial court reports may be sent back in learned trial court.
Lordship, I kindly direct
Along with the order also, it can be.
With a copy,
Dusty.
a copy of
Yes.
this. Yes. Oh, Didi. Oh, okay. Any more? We have one organization matter, huh? Two.
Much obliged.
Obliged, Lordship.
May I please your ladyship?
She's
She will
gone.
come up in a few minutes.
If you urgently require, she's going to sit at 2. Mention at 2.
Shanali Kalita, telling you to mention it too.
Thank you so much.
There is some problem with your network also.
I'm aware the network's not that great here.
You have to mention it too if there is any urgent matter. That is what the court master is saying.
Yes, thank you.